Question 1. Operational review demonstrates that the current Queensland Concealable Firearms License Application Processing System is experiencing significant backlogs. To address this, what is the most appropriate strategy to optimize the process while strictly adhering to the Weapons Act 1990 (QLD) and its associated regulations? Option A. Prioritize rapid processing by bypassing mandatory referee reports and mental health assessments where legally required by the Weapons Act 1990 (QLD), focusing only on basic identification and application form completion. Option B. Expedite processing by accepting applicant self-declarations for all information, including genuine need and suitability, without independent verification to reduce turnaround times. Option C. Implement a multi-stage verification process that includes initial application completeness checks, thorough statutory background checks, criminal, mental health, and referee assessments, and a final decision based on meeting all legal criteria with comprehensive documentation. Option D. Delegate the final decision-making authority for all applications, including complex cases, to junior administrative staff with minimal oversight to increase throughput. The correct answer is C. Implement a multi-stage verification process that includes initial application completeness checks, thorough statutory background checks, criminal, mental health, and referee assessments, and a final decision based on meeting all legal criteria with comprehensive documentation. Explanation. Scenario analysis. This scenario presents a professional challenge in managing the administrative workflow for Queensland Concealable Firearms license applications. The core challenge lies in balancing the need for efficient processing with the absolute imperative of adhering to the strict legislative requirements and ensuring public safety, as mandated by the Weapons Act 1990 (QLD) and associated regulations. Inaccurate or incomplete processing can lead to delays, incorrect license issuance, or even breaches of the law, necessitating careful judgment and a thorough understanding of the procedural framework. Correct approach analysis. The best professional practice involves a systematic, multi-stage verification process that prioritizes legislative compliance and risk mitigation. This approach entails an initial review of the application for completeness and accuracy against the prescribed requirements of the Weapons Act 1990 (QLD). Following this, a thorough background check, including criminal history, mental health assessments, where applicable and legally permissible, and referee checks, must be conducted in accordance with the Act's provisions. Finally, a decision is made based on whether all statutory criteria are met, with clear documentation of the rationale. This methodical process ensures that every application is assessed against the legal standards, safeguarding against the improper issuance of licenses and upholding public safety, which is the paramount objective of firearms licensing legislation in Queensland. Incorrect approaches analysis. One incorrect approach involves expediting the process by relying solely on the applicant's self-declaration for critical information without independent verification. This fails to meet the statutory requirement for thorough assessment and due diligence mandated by the Weapons Act 1990 (QLD), which requires the licensing authority to be satisfied that the applicant is a fit and proper person, and that the license is genuinely required. This approach creates a significant risk of issuing licenses to unsuitable individuals, undermining public safety. Another incorrect approach is to delegate the final decision-making authority to junior staff without adequate training or oversight, particularly concerning complex or borderline cases. The Weapons Act 1990 (QLD) places a clear responsibility on the licensing authority to make informed decisions. Overdelegation without proper safeguards can lead to inconsistent application of the law and potentially erroneous decisions, failing to uphold the integrity of the licensing system. A further incorrect approach is to prioritize speed of processing over the completeness of background checks, such as overlooking the requirement for referee reports or mental health assessment when legally mandated. The Act specifies the types of checks required to assess an applicant's suitability. Omitting these steps constitutes a direct contravention of the legislative framework and compromises the ability to make a legally sound and safe decision. Professional reasoning. Professionals in this field must adopt a risk-based, compliance-driven decision-making framework. This involves 1. Understanding the specific legislative requirements of the Weapons Act 1990 QLD, and associated regulations. 2. Implementing robust procedural checks and balances to ensure all statutory criteria are met. 3. Prioritizing public safety and the integrity of the licensing system. 4. Documenting all steps and decisions meticulously. 5. Seeking guidance or escalating complex cases when necessary. This structured approach ensures that decisions are not only efficient but, more importantly, legally sound and ethically responsible. Question 2. In Queensland, during the assessment of an application for a concealable firearm license, a licensing officer reviews the applicant's submitted documentation and notes that while the applicant has provided a referee statement, the statement contains a vague comment about the applicant having a bit of a temper in the past, though no specific incidents are detailed. The applicant has otherwise provided all required forms and declared no criminal convictions or mental health issues. What is the most appropriate course of action for the licensing officer to ensure compliance with the Weapons Act 1990 QLD and uphold public safety? Option A. Request further clarification from the referee regarding the temper comment and conduct additional background checks if deemed necessary, while proceeding with the assessment based on the available information if no further significant concerns arise. Option B. Disregard the referee's comment entirely, as it is not a formal declaration of unsuitability, and focus solely on the applicant's self-declared information and criminal record. Option C. Immediately reject the application based on the referee's comment, as any mention of a temper indicates a potential risk to public safety. Option D. Proceed with issuing the license, as the comment is vague and no specific incidents or convictions are reported, assuming the applicant is otherwise suitable. Correct answer is A. Request further clarification from the referee regarding the temper comment and conduct additional background checks if deemed necessary, while proceeding with the assessment based on the available information if no further significant concerns arise. Explanation. The assessment process reveals a common challenge in firearms licensing, balancing the applicant's right to apply with the paramount public safety obligations of the licensing authority in Queensland. This scenario is professionally challenging because it requires a nuanced interpretation of the Weapons Act 1990 QLD and its associated regulations, specifically concerning the assessment of an applicant's suitability and the potential risk they may pose. The licensing officer must exercise careful judgment to avoid both the arbitrary denial of a license and the issuance of a license to an individual who may be a danger to themselves or others. The best professional approach involves a thorough, objective, and documented assessment of all provided information, coupled with a proactive investigation into any concerning aspects of the application. This includes meticulously reviewing the applicant's stated reasons for needing a concealable firearm, verifying the authenticity and completeness of all supporting documentation, and conducting a comprehensive background check that extends beyond immediate criminal records to include any relevant mental health history or documented instances of concerning behavior that might indicate a risk. This approach is correct because it directly aligns with the principles of the Weapons Act 1990 QLD, which mandates that a license must not be issued if the applicant is deemed an unacceptable risk to public safety. The Act requires licensing authorities to be satisfied that the applicant is a fit and proper person, and this requires diligent inquiry and a holistic evaluation of the applicant's circumstances. Ethical considerations also demand that the licensing authority prioritizes public safety above all else, ensuring that firearms are only accessible to those who can demonstrate responsible ownership and a genuine, lawful need, without posing an undue risk. An incorrect approach would be to solely rely on the applicant's self-declaration of good character and mental well-being, without independent verification. This fails to meet the statutory obligation to be satisfied of the applicant's suitability and creates a significant public safety risk by potentially overlooking undisclosed issues. Another incorrect approach is to dismiss concerns raised by a referee without further investigation. Referees are a crucial part of the assessment process, and their feedback, even if seemingly minor, must be explored to understand the context and potential implications for public safety. Failing to do so abrogates the licensing authority's duty of care. Finally, an approach that prioritizes administrative expediency over thoroughness, such as approving the license based on a cursory review of the paperwork, is fundamentally flawed. This disregards the serious nature of firearms licensing and the potential consequences of issuing a license to an unsuitable individual, thereby failing to uphold the spirit and letter of the Weapons Act 1990, QLD. Professionals should employ a decision-making framework that begins with a clear understanding of the legislative requirements and ethical obligations. This involves a systematic review of all application components, identifying potential red flags or areas requiring further scrutiny. Where concerns arise, a proactive investigative stance should be adopted, involving further inquiries, interviews, or requests for additional documentation. The decision should be based on a balanced assessment of the evidence, always erring on the side of caution when public safety is at stake, and ensuring that all decisions are well documented and justifiable under the relevant legislation. Question 3. Cost-benefit analysis shows that a thorough and honest disclosure of all past interactions with law enforcement, including minor incidents that did not result in charges, is the most efficient pathway to obtaining a concealable firearm license in Queensland. Considering the requirements of the Firearms Act 1996, QLD, which of the following approaches best aligns with this principle and the QPS's assessment of an applicant's suitability? Option A. Only disclose past interactions with law enforcement that resulted in a criminal conviction, as these are the only events that directly impact the applicant's suitability. Option B. Omit any mention of past police interventions for minor disputes that were resolved without formal proceedings, assuming they are not relevant to a firearm license application. Option C. Fully disclose all past interactions with law enforcement, regardless of whether they resulted in charges or convictions, to ensure the Queensland Police Service has a complete understanding of the applicant's history. Option D. Rely on the Queensland Police Service's background checks to uncover all relevant information, as direct disclosure of minor incidents is unnecessary if they are not officially recorded as convictions. The correct answer is C. Fully disclose all past interactions with law enforcement, regardless of whether they resulted in charges or convictions, to ensure the Queensland Police Service has a complete understanding of the applicant's history. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an applicant to navigate the Queensland Police Service's QPS requirements for a concealable firearm license while also demonstrating a genuine reason for possessing such a firearm, which is a critical gatekeeping function. The challenge lies in accurately and truthfully presenting information that satisfies both the administrative and the substantive requirements of the legislation, particularly the Firearms Act 1996, QLD, and its associated regulations. Misrepresenting information, even if seemingly minor, can have significant consequences, including license refusal and potential legal repercussions. Correct approach analysis. The best professional practice involves a thorough and honest disclosure of all relevant information to the QPS, including any past interactions with law enforcement that might be perceived as negative, even if they did not result in a conviction. This approach is correct because Section 11 of the Firearms Act 1996, QLD, mandates that an applicant must satisfy the Commissioner of Police that they are a fit and proper person to hold a license. This includes demonstrating that they have not, within a specified period, been convicted of certain offenses or been subject to certain orders. Furthermore, the QPS conducts a comprehensive background check and withholding information, even if the applicant believes it is not relevant or might be viewed unfavorably, can be interpreted as a lack of honesty and therefore a failure to satisfy the fit and proper person requirement. Full disclosure allows the QPS to make an informed decision based on all available facts, adhering to the spirit and letter of the law. Incorrect approaches analysis. One incorrect approach is to omit any mention of a past intervention by police for a domestic dispute, even if no charges were laid, and the matter was resolved without formal proceedings. This is professionally unacceptable because the QPS background check is designed to uncover all relevant interactions, and the absence of a conviction does not equate to an absence of a relevant event. The legislation requires the Commissioner to be satisfied of the applicant's suitability, and past incidents, even if minor or resolved informally, can be considered by the Commissioner in assessing this suitability. Failing to disclose such an event can be seen as an attempt to mislead the authorities, directly contravening the fit and proper person requirement. Another incorrect approach is to only disclose information that directly relates to a criminal conviction, assuming that anything else is irrelevant. This is professionally unacceptable, as it demonstrates a narrow interpretation of the licensing requirements. The QPS is not solely concerned with conviction. They are concerned with the applicant's overall history and behavior that might indicate a risk. Past disputes, even if not criminalized, can provide insight into an individual's temperament and their ability to handle stressful situations responsibly, which are crucial considerations for firearm ownership. A further incorrect approach is to rely on the assumption that the QPS will find out about any relevant information independently, and therefore disclosure is unnecessary. This is professionally unacceptable, as it shifts the onus of full disclosure from the applicant to the QPS. The Firearms Act 1996, QLD, places a positive obligation on the applicant to provide all necessary information to satisfy the commissioner. Relying on independent discovery is a passive approach that fails to meet this obligation and can be viewed as a deliberate omission. Professional reasoning. Professionals in this field must adopt a proactive and transparent approach. The decision-making process should involve a thorough review of the application requirements, understanding that the QPS seeks to ensure public safety. This means erring on the side of caution and disclosing all potentially relevant information, even if it seems minor or resolved. Professionals should advise their clients that honesty and completeness are paramount, as any attempt to conceal information can lead to severe consequences. The guiding principle is to enable the QPS to make a fully informed decision based on a complete picture of the applicant's history. Question 4. Operational review demonstrates that an applicant for a Queensland concealable firearm license has declared a history of domestic disputes with a former partner, although no charges were ever laid. What is the most appropriate course of action for the licensing authority? Option A. Advise the applicant that any history of domestic disputes, regardless of charges, automatically disqualifies them from obtaining a firearm license in Queensland. Option B. Immediately refuse the license application based on the mention of domestic disputes, prioritizing public safety above all else without further inquiry. Option C. Conduct a thorough investigation into the nature and circumstances of the domestic disputes, seeking further information from the applicant and potentially other relevant sources, to assess the applicant's suitability as a fit and proper person under the Queensland Weapons Act 1990. Option D. Accept the applicant's declaration that no charges were laid and proceed with the license application, considering the disputes to be resolved or unsubstantiated. The correct answer is C. Conduct a thorough investigation into the nature and circumstances of the domestic disputes, seeking further information from the applicant and potentially other relevant sources, to assess the applicant's suitability as a fit and proper person under the Queensland Weapons Act 1990. Explanation. Scenario analysis. This scenario is professionally challenging because it requires balancing the applicant's stated intention for firearm ownership with the stringent requirements of the Queensland Weapons Act 1990 and associated regulations. The applicant's history of domestic disputes, even if not resulting in formal charges, raises significant public safety concerns and necessitates a thorough, objective assessment of their suitability to possess a concealable firearm. Failure to adequately investigate these concerns could have severe consequences for public safety and lead to regulatory breaches. Correct approach analysis. The best professional approach involves a comprehensive investigation that directly addresses the applicant's stated purpose for the firearm and thoroughly explores the reported domestic disputes. This includes obtaining detailed statements from the applicant regarding the disputes, contacting relevant parties with appropriate consent or legal authority, and reviewing any available police records or court documents. This approach is correct because it aligns with the Queensland Weapons Act 1990, which mandates that the Commissioner of Police must be satisfied that the applicant is a fit and proper person to possess a firearm. The Act requires consideration of any factors that might indicate the applicant is likely to pose a risk to themselves or others. A thorough investigation into domestic disputes directly addresses this requirement by assessing the applicant's temperament, history of conflict resolution, and potential for violence, which are critical to determining suitability. Incorrect approaches analysis. One incorrect approach involves solely relying on the applicant's self-declaration and the absence of formal charges. This fails to meet the fit and proper person test, as it neglects to investigate credible information that could indicate a risk. Absence of formal charges does not equate to the absence of concerning behavior or a propensity for violence, which is a key consideration under the Act. Another incorrect approach is to dismiss the domestic dispute information as irrelevant because no charges were laid. This is a critical regulatory failure. The Weapons Act 1990 requires a proactive assessment of risk, not just a reactive one based on criminal convictions. Information about domestic disputes, even without charges, can be highly indicative of an applicant's suitability and must be investigated. A further incorrect approach is to immediately refuse the license based solely on the mention of domestic disputes without conducting any further investigation. While public safety is paramount, a refusal must be based on a thorough assessment of all relevant information and a demonstrable failure to meet the fit and proper person criteria. An initial mention of disputes warrants investigation, not automatic disqualification, unless the investigation reveals clear and present dangers. Professional reasoning. Professionals in this role must adopt a risk-based assessment framework. This involves identifying potential risks, gathering all relevant information to assess those risks, and making a decision based on the totality of the evidence in accordance with the governing legislation. The process should be objective, thorough, and focused on the applicant's demonstrated suitability and the public interest. When information arises that could impact an applicant's suitability, a diligent investigation is not optional but a mandatory component of the decision-making process. Question 5. The evaluation methodology shows that when assessing an application for a Queensland Concealable Firearms license, an officer receives an application form detailing the applicant's stated genuine reason for possession and supporting documentation. What is the most appropriate process to ensure compliance with the Weapons Act 1990, QLD? Option A. Expedite the application based on the applicant's stated genuine reason, assuming the provided documentation is accurate and complete. Option B. Rely solely on the references provided by the applicant and their submitted documentation without conducting an independent interview or further verification. Option C. Conduct a thorough review of all submitted documentation, cross-reference information with relevant databases, and conduct a formal interview with the applicant to verify their genuine reason and assess their suitability. Option D. Dismiss any concerns raised during the background check if the applicant provides a plausible explanation, prioritizing the applicant's right to apply. The correct answer is C. Conduct a thorough review of all submitted documentation, cross-reference information with relevant databases, and conduct a formal interview with the applicant to verify their genuine reason and assess their suitability. Explanation. The evaluation methodology shows that managing the process of obtaining a Queensland Concealable Firearms license requires a meticulous adherence to the Weapons Act 1990, QLD, and its associated regulations. This scenario is professionally challenging because it involves balancing the applicant's right to apply for a license with the paramount public safety obligations of the licensing authority. A thorough assessment of the applicant's suitability, including their character, genuine reason for possessing a firearm, and mental health, is critical. Misinterpreting or overlooking any aspect of the application process can have severe consequences, including the potential for a license to be granted to an unsuitable individual, thereby compromising community safety. The best approach involves a comprehensive review of all submitted documentation, cross-referencing information with relevant databases, and conducting a thorough interview with the applicant. This systematic process ensures that all statutory requirements under the Weapons Act 1990, QLD, are met, and that a fully informed decision can be made. Specifically, this includes verifying the applicant's identity, confirming their genuine reason for needing a concealable firearm, as defined by the Act, assessing their mental and physical fitness, and conducting a thorough background check for any disqualifying factors, such as a history of violence or substance abuse. This aligns with the legislative intent to permit firearm ownership only for those who can demonstrate a legitimate need and are demonstrably safe to possess such weapons. An incorrect approach would be to expedite the application process based solely on the applicant's stated genuine reason, without independently verifying its legitimacy or conducting a comprehensive background check. This fails to meet the statutory obligation to ensure public safety and could lead to a license being issued to someone who poses a risk. Another incorrect approach is to dismiss concerns raised during the background check without further investigation, assuming the applicant is truthful. This neglects the duty of care to thoroughly assess all potential risks and contravenes the principles of due diligence required under Queensland firearms legislation. Finally, relying solely on references provided by the applicant without independently corroborating their statements or conducting a formal interview would be a flawed strategy, as it bypasses crucial opportunities to assess the applicant's character and suitability directly. Professionals should adopt a decision-making framework that prioritizes statutory compliance and public safety. This involves a step-by-step verification process for every piece of information provided, a commitment to thorough background checks, and a structured interview process designed to elicit relevant information about the applicant's suitability. Any doubts or discrepancies should trigger further investigation, not dismissal. The ultimate decision must be grounded in evidence that demonstrates the applicant meets all legal requirements and poses no undue risk to the community. Question 6. System analysis indicates that an applicant for a Queensland concealable firearms license has a past incident involving a public disturbance that, while not resulting in a conviction, involved a significant altercation. The applicant is unsure whether to disclose this incident, believing it was a long time ago and minor. Which approach best ensures a successful and compliant application process? Option A. Omit the incident from the application, assuming that since there was no conviction, it is not relevant to the firearms license assessment. Option B. Briefly mention the incident on the application form but downplay its significance, stating it was a minor disagreement that resolved itself. Option C. Fully disclose the incident on the application form and attach a detailed, truthful, and contextualized explanation of the events, including the applicant's role and the resolution. Option D. State on the application that there were no incidents that resulted in a conviction, without providing any further details about the public disturbance. The correct answer is C. Fully disclose the incident on the application form and attach a detailed, truthful, and contextualized explanation of the events, including the applicant's role and the resolution. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an applicant to navigate a complex regulatory framework with significant consequences for noncompliance. The Queensland Police Service, as the issuing authority, has a duty to ensure public safety by rigorously assessing the suitability of individuals seeking to possess firearms. The applicant's past behavior, even if seemingly minor or distant, can be interpreted as relevant to their capacity to safely and responsibly handle a firearm. The challenge lies in presenting information accurately and comprehensively while understanding the potential impact of past events on the assessment process. Careful judgment is required to anticipate how the Queensland Police Service might interpret the provided information and to proactively address any potential concerns. Correct approach analysis. The best professional approach involves a proactive and transparent disclosure of all relevant information, including past incidents that might be perceived negatively, even if the applicant believes they are minor or resolved. This means fully completing the application form and attaching a detailed, truthful, and contextualized explanation of the past incident. This approach is correct because it aligns with the fundamental principles of the Weapons Act 1990, QLD, and associated regulations, which mandate honesty and full disclosure in firearm license applications. Section 10 of the Weapons Act 1990, QLD, outlines the eligibility criteria, including considerations of a person's character and suitability. By providing a comprehensive explanation, the applicant demonstrates responsibility and allows the Queensland Police Service to make an informed decision based on complete information, rather than discovering the information later, which could lead to a presumption of attempted concealment. This approach fosters trust and facilitates a fair assessment. Incorrect approaches analysis. Providing a partial or misleading account of the past incident or omitting it entirely is an incorrect approach. This failure to disclose relevant information directly contravenes the spirit and letter of the Weapons Act 1990, QLD, and its associated regulations regarding the application process. Such an omission could be interpreted as an attempt to conceal information, which would severely undermine the applicant's credibility and likely lead to the refusal of the license. It also prevents the Queensland Police Service from conducting a thorough risk assessment, potentially compromising public safety. Seeking to downplay the significance of the incident without providing a factual account is also an incorrect approach. While context is important, the applicant's subjective assessment of significance should not replace objective disclosure. The Queensland Police Service is responsible for determining the relevance and impact of past events. Failing to provide a clear and factual narrative leaves the interpretation to the authorities, who may err on the side of caution if information is presented ambiguously or defensively. Relying solely on the fact that the incident did not result in a conviction, without providing any details, is an insufficient approach. While a conviction is a significant factor, the Weapons Act 1990, QLD, allows for the consideration of a broader range of factors related to a person's suitability, including past behavior that may not have led to a formal conviction, but still raises concerns about judgment or responsibility. The absence of a conviction does not automatically equate to suitability for a firearms license. Professional reasoning. Professionals should adopt a framework of complete transparency and proactive disclosure when dealing with regulatory applications, especially those concerning public safety. This involves understanding the specific legislative requirements of the jurisdiction, in this case, Queensland's Weapons Act 1990, anticipating potential concerns the regulatory body might have, and providing clear, factual, and contextualized information to address those concerns upfront. The decision-making process should prioritize honesty, accuracy, and a thorough understanding of the applicant's obligations under the law. Question 7. Implementation of the Queensland Concealable Firearms licensing process requires careful consideration of applicant suitability. If an applicant for a concealable firearms license in Queensland discloses recent significant personal distress, including a relationship breakdown and feelings of anger, what is the most appropriate and legally compliant course of action for the licensing authority? Option A. Obtain a comprehensive assessment from a registered psychologist or psychiatrist regarding the applicant's current mental and emotional state and their fitness to possess a firearm. Option B. Accept the applicant's assurance that their anger is temporary and will not impact their ability to safely handle a firearm. Option C. Grant a short-term license with a mandatory review in 6 months, without seeking any professional medical opinion on their current state. Option D. Immediately refuse the license application based on the expressed feelings of anger, without further investigation. The correct answer is A. Obtain a comprehensive assessment from a registered psychologist or psychiatrist regarding the applicant's current mental and emotional state and their fitness to possess a firearm. Explanation. This scenario is professionally challenging because it requires balancing the applicant's stated intention with the objective assessment of their suitability for a concealable firearm license under Queensland law. The applicant's personal circumstances, including a recent relationship breakdown and expressed feelings of anger, raise concerns about their immediate emotional state and potential risk, which are critical considerations for public safety. Careful judgment is required to ensure that the licensing process is rigorous and upholds the principles of responsible firearm ownership and community safety as mandated by Queensland legislation. The best approach involves a thorough, objective assessment of the applicant's current mental and emotional state, directly addressing the concerns raised by their recent personal difficulties and expressed anger. This involves seeking professional medical advice, specifically from a registered psychologist or psychiatrist, to evaluate the applicant's fitness to possess a firearm. This aligns with the Queensland Weapons Act 1990, which requires the Commissioner of Police to be satisfied that a person is a fit and proper person to hold a license. A fit and proper person is one who is unlikely to endanger themselves or others. Documented evidence of a professional assessment directly addresses this requirement by providing an expert opinion on the applicant's current psychological stability and their capacity to handle a firearm responsibly, thereby mitigating potential risks. An incorrect approach would be to solely rely on the applicant's assurance that their anger is temporary and will not affect their firearm handling. This fails to acknowledge the potential for heightened emotional states to impair judgment and increase risk, and it bypasses the statutory requirement for objective assessment of fitness. It prioritizes the applicant's self-assessment over a professional, evidence-based evaluation, which is a regulatory failure. Another incorrect approach would be to immediately refuse the license based on the applicant's expressed anger without further investigation or professional assessment. While public safety is paramount, a refusal must be based on substantiated grounds. Blanket refusal without exploring the applicant's current mental state through appropriate professional channels could be seen as an arbitrary decision and may not fully comply with the principles of procedural fairness and evidence-based decision-making required under Queensland administrative law. A third incorrect approach would be to approve the license, but impose a very short-term license with a mandatory review, without obtaining any professional medical opinion. While a review mechanism is important, approving a license for a potentially unstable individual without expert input into their current mental state is a significant risk. The primary assessment of fitness must be robust and evidence-based before any license is granted, even with a short review period. Professionals should adopt a decision-making process that prioritizes objective evidence and regulatory compliance. This involves 1. Identifying potential risks based on applicant information. 2. Seeking expert advice, e.g., medical, psychological, to objectively assess those risks. 3. Evaluating the evidence against the statutory criteria for license eligibility. 4. Documenting the decision-making process and the rationale for approval or refusal, ensuring it is supported by evidence and aligns with legislative requirements. Question 8. To address the challenge of ensuring compliance with Queensland's firearms regulations when selling a concealable firearm, a dealer receives a potential buyer who presents a license that appears valid, but has a slightly different expiry date than what the dealer recalls from a previous interaction. What is the most prudent course of action for the dealer to take to uphold their legal obligations and professional responsibilities? Option A. Proceed with the sale, assuming the buyer's license is still valid as they have purchased firearms from the dealership before. Option B. Accept the buyer's verbal assurance that their license application is in process and that they are authorized to purchase the firearm. Option C. Immediately verify the current validity and specific firearm authorization of the buyer's Queensland Concealable firearm license through official channels before proceeding with any sale. Option D. Complete the sale based on the visual appearance of the license, without independently confirming its current status or specific firearm authorization. The correct answer is C. Immediately verify the current validity and specific firearm authorization of the buyer's Queensland Concealable firearm license through official channels before proceeding with any sale. Explanation. Scenario analysis. This scenario presents a professional challenge for a firearms dealer in Queensland due to the strict regulatory environment surrounding the licensing and sale of concealable firearms. Dealer must navigate the requirements of the Weapons Act 1990, QLD, and associated regulations, ensuring all due diligence is performed before transferring a firearm. Failure to do so can result in severe penalties, including license suspension or cancellation, and criminal charges. The core challenge lies in balancing efficient business operations with the paramount responsibility of public safety and adherence to legal obligations. Correct approach analysis. The best professional practice involves meticulously verifying the validity and currency of the buyer's Queensland Concealable firearm license and ensuring it authorizes the specific type of firearm being purchased. This includes confirming the license number, expiry date, and that the category of license permits the acquisition of the firearm in question. This approach is correct because it directly aligns with the requirements of the Weapons Act 1990, QLD, specifically sections pertaining to the sale and transfer of firearms, which mandate that a dealer must not sell a firearm to a person unless that person is authorized by a license to possess it. This proactive verification minimizes the risk of an illegal sale and upholds the dealer's duty of care. Incorrect approaches analysis. One incorrect approach involves proceeding with the sale based solely on the buyer's assurance that they have applied for a license, without independently verifying its existence or validity. This is a regulatory failure because the law requires proof of a valid license at the time of sale, not just an application. It creates a significant risk of an unauthorized person acquiring a firearm, undermining public safety, and contravening the Weapons Act 1990, QLD. Another incorrect approach is to rely on a previous transaction with the same customer as sufficient proof of current license status. Past compliance is positive, license details can change, and licenses can expire or be revoked. This approach is a regulatory failure as it does not fulfill the ongoing obligation to verify license validity for each individual transaction, potentially leading to an illegal sale if the license is no longer current. A further incorrect approach is to assume that a buyer presenting a license that appears legitimate is sufficient, without cross-referencing the license details against official records or confirming its authorization for the specific firearm. This bypasses essential due diligence and fails to meet the legal standard of care expected of a firearms dealer. The Weapons Act 1990, QLD, requires more than superficial inspection. It necessitates confirmation that the license permits the acquisition of the particular firearm being sold. Professional reasoning. Professionals in this field must adopt a systematic due diligence process for every firearm transaction. This involves understanding the specific legislative requirements of Queensland, maintaining up-to-date knowledge of license categories and firearm classifications, and implementing robust internal procedures for verifying customer credentials. A risk-based approach, where the highest level of scrutiny is applied to all firearm sales, is essential. Professionals should always err on the side of caution and seek clarification or confirmation from the relevant authorities if there is any doubt about a buyer's eligibility or license validity. Question 9. The review process indicates that a referee for a Queensland concealable firearm license application has a close personal friendship with the applicant, spanning several years. The referee is aware of some past instances where the applicant has exhibited a volatile temper, though these incidents have not resulted in any formal charges or documented complaints. The referee is concerned that a completely negative reference might jeopardize the applicant's chances, while a wholly positive one would be dishonest. What is the most appropriate course of action for the referee in this situation? Option A. Provide a candid assessment of the applicant's suitability, detailing both positive attributes and any concerns regarding their temperament, while also disclosing the nature and duration of their personal relationship. Option B. Provide a glowing, entirely positive reference to avoid negatively impacting the applicant's chances, assuming the applicant is generally a good person despite minor temper issues. Option C. Provide a reference that focuses solely on the applicant's positive qualities and completely omits any mention of past temper issues to maintain the friendship. Option D. Decline to provide a reference altogether, citing the personal friendship as a reason for potential bias, without further elaboration. The correct answer is A. Provide a candid assessment of the applicant's suitability, detailing both positive attributes and any concerns regarding their temperament, while also disclosing the nature and duration of their personal relationship. Explanation. The review process indicates a potential conflict of interest and a failure to adhere to the Queensland Police Services, QPS, internal policies regarding the assessment of firearm license applications. This scenario is professionally challenging because it requires the applicant's referee to balance their personal relationship with the applicant against their statutory duty to provide an objective and truthful assessment. The referee must consider the implications of their recommendation on public safety and the integrity of the firearms licensing system in Queensland. The best professional approach involves the referee providing a candid and objective assessment based on their genuine knowledge of the applicant's suitability, including any relevant concerns, and clearly disclosing the nature and extent of their relationship with the applicant. This approach aligns with the principles of the Weapons Act 1990, QLD, and the associated regulations, which mandate that referees must be of good character and provide honest information to assist the QPS in determining an applicant's suitability to possess a concealable firearm. Transparency about the relationship ensures the QPS can appropriately weigh the referee's opinion. An incorrect approach would be to provide a recommendation that is unduly influenced by the personal relationship, leading to an inaccurate or misleading assessment. This could involve downplaying or omitting significant concerns about the applicant's temperament or history, thereby failing to uphold the referee's statutory obligation to provide truthful information. Such an omission or misrepresentation could have serious consequences for public safety if the applicant is subsequently deemed unsuitable. Another incorrect approach is to refuse to provide a reference solely due to the personal relationship, without considering whether the applicant is genuinely suitable and whether the referee can provide an objective assessment despite the relationship. This fails to assist the QPS in its duty to assess applicants thoroughly. Finally, providing a reference that is overly enthusiastic and lacks any critical evaluation, simply to maintain the personal relationship, is also professionally unacceptable, as it prioritizes personal comfort over public safety and regulatory compliance. Professionals in this situation should employ a decision-making framework that prioritizes their statutory obligations and ethical responsibilities. This involves first understanding the specific requirements of the Weapons Act 1990, QLD, and QPS guidelines for referees. They should then objectively assess their knowledge of the applicant against these requirements, considering all relevant information, both positive and negative. If a genuine conflict of interest or inability to provide an objective assessment exists, they should consider declining to act as a referee and explain their reasons to the applicant. If they can provide an objective assessment, they must do so truthfully and transparently, disclosing any personal relationship that might be perceived to influence their judgment. Question 10. Examination of the data shows a customer in Queensland wishes to purchase a concealable firearm from your licensed dealership. The customer presents a valid Queensland concealable firearm license. The current fee schedule for firearm license transfers in Queensland, as published by the Queensland Police Service, indicates a base fee of $75.00 for the transfer of a concealable firearm. You have a standard margin of $20.00 you aim to add to all transfer fees for administrative costs. What is the total amount you should charge the customer for the firearm license transfer? Option A. The customer should be informed of the base fee and asked to suggest an amount for the transfer. Option B. $75.00. Option C. $95.00. Option D. $75.00 plus any additional administrative costs you deem appropriate. The correct answer is B. $75.00. Explanation. This scenario presents a professional challenge for a firearms dealer in Queensland due to the strict regulatory environment surrounding the sale and transfer of firearms, particularly concerning the verification of license validity and the accurate calculation of associated fees. The dealer must navigate the requirements of the Weapons Act 1990, QLD, and associated regulations to ensure compliance and prevent the illegal transfer of a firearm. The core difficulty lies in accurately calculating the transfer fee, which is dependent on the category of the firearm and the specific type of license being transferred. Miscalculation can lead to financial penalties for the dealer or, more critically, a failure to meet statutory obligations, potentially facilitating an unlawful acquisition. The correct approach involves meticulously verifying the validity of the buyer's Queensland concealable firearm license and then accurately calculating the applicable transfer fee based on the firearms category as defined in the Weapons Act 1990, QLD. This requires consulting the current fee schedule, which is typically published by the Queensland Police Service or relevant government department. For a concealable firearm, the transfer fee is a fixed amount as stipulated by the legislation. The dealer must ensure this fee is correctly identified and charged. This approach is correct because it directly adheres to the legislative requirements for firearm transfers, ensuring that all statutory obligations are met. The buyer possesses a valid license for the specific firearm category, and the correct government fee is collected. An incorrect approach would be to assume the transfer fee based on a previous transaction or a general understanding, without consulting the official fee schedule. This fails to account for any legislative amendments or specific nuances in fee calculation that might apply. Another incorrect approach is to charge a reduced fee without explicit legislative authority or to defer the fee calculation to the buyer. This bypasses the dealer's statutory responsibility to ensure the correct fee is collected and remitted, potentially leading to underpayment of government revenue and noncompliance. A further incorrect approach would be to proceed with the transfer without confirming the buyer's license is current and valid for the specific firearm category, which is a fundamental requirement under the Weapons Act 1990, QLD, and a serious breach of due diligence. Professionals should employ a decision-making framework that prioritizes regulatory compliance and due diligence. This involves 1. Identifying all relevant legislative requirements, e.g., Weapons Act 1990 QLD, associated regulations, fee schedules. 2. Gathering all necessary information, e.g., buyer's license details, firearm category. 3. Performing accurate calculations based on verified data and official fee structures. 4. Documenting all steps taken and calculations performed for audit purposes. 5. Seeking clarification from regulatory authorities if any ambiguity exists. Question 11. Upon reviewing the requirements for a Queensland concealable firearms license, a security guard employed by a private firm in Brisbane discovers that certain personal circumstances, which they are legally obligated to disclose to the Queensland Police Service, might also be a point of concern for their employer regarding their continued suitability for their role. What is the most professionally responsible course of action for the security guard to take regarding their employer? Option A. Conceal the firearms license application and the personal circumstances from their employer until the license is approved to avoid potential complications. Option B. Proactively inform their employer about the firearms license application and the personal circumstances that are relevant to both the license and their employment, seeking their understanding and guidance. Option C. Inform the employer only after the firearms license has been successfully granted, without prior disclosure of the personal circumstances. Option D. Assume the employer will be supportive and proceed with the license application without any prior discussion, only informing them if issues arise. The correct answer is B. Proactively inform their employer about the firearms license application and the personal circumstances that are relevant to both the license and their employment, seeking their understanding and guidance. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an applicant to navigate the complex requirements for obtaining a Queensland concealable firearms license while also managing the expectations and potential concerns of their employer. The applicant's role as a security guard, which inherently involves handling firearms, adds a layer of scrutiny, balancing personal licensing requirements with professional obligations and ensuring transparency with an employer, especially when personal circumstances might impact license eligibility, demands careful judgment and adherence to regulatory processes. Correct approach analysis. The best professional approach involves proactively and transparently informing the employer about the application for a concealable firearms license and any associated personal circumstances that might be relevant to the license's approval or the applicant's suitability for their role. This approach is correct because it aligns with the principles of honesty and integrity expected of individuals seeking to possess firearms, and it respects the employer's right to be informed about factors that could affect an employee's ability to perform their duties or comply with licensing regulations. Specifically, under the Weapons Act 1990, QLD, and associated regulations, applicants are required to disclose relevant information that may impact their eligibility. Open communication with the employer facilitates compliance with these disclosure obligations and allows for a collaborative approach to any potential issues, ensuring that the employer is aware of the licensing process and can support the employee appropriately, or make informed decisions regarding their employment if necessary. Incorrect approaches analysis. One incorrect approach is to conceal the application and the personal circumstances from the employer. This is professionally unacceptable as it breaches the duty of honesty and transparency. It could lead to disciplinary action from the employer if discovered, and potentially jeopardize the firearms license application if the personal circumstances are deemed relevant by the Queensland Police Service, QPS, and the employer's knowledge of them is considered a factor in assessing the applicant's suitability. Another incorrect approach is to only inform the employer after the license has been approved, without prior disclosure of any potentially sensitive personal circumstances. While this might seem like a way to avoid initial complications, it still lacks the proactive transparency that is professionally expected. If the personal circumstances were such that they could have influenced the employer's decision-making or required specific workplace accommodations or considerations during the application process, delaying this information is a failure of professional conduct. A further incorrect approach is to assume the employer will automatically approve of the license application without providing any context or seeking their input, especially if the personal circumstances are significant. This demonstrates a lack of professional consideration for the employer's responsibilities and potential concerns regarding workplace safety and compliance with their own operational policies. It places the employer in a reactive rather than proactive position, which is not conducive to a sound professional relationship. Professional reasoning. Professionals in Queensland seeking a concealable firearms license, particularly those in roles involving firearms, should adopt a proactive and transparent communication strategy. This involves understanding the disclosure requirements of the Weapons Act 1990, QLD, assessing any personal circumstances that might be relevant to license eligibility or workplace suitability, and then openly discussing these with their employer. This approach fosters trust, ensures compliance, and allows for informed decision-making by all parties involved. The decision-making process should prioritize honesty, regulatory adherence, and consideration of the employer's legitimate interests. Question 12. When evaluating an application for a concealable firearm license in Queensland, and an applicant has a history of a domestic dispute that was resolved without charges being laid, what is the most appropriate course of action for the applicant regarding disclosure to the Queensland Police Service? Option A. Assume the domestic dispute is not relevant to the firearm license application because it was resolved without charges. Option B. Proactively and comprehensively disclose the domestic dispute, including its nature, resolution, and any related circumstances, to the Queensland Police Service. Option C. Provide a vague or misleading description of the domestic dispute, downplaying its severity. Option D. Only disclose the domestic dispute if specifically questioned about it by the Queensland Police Service. Correct answer is B. Proactively and comprehensively disclose the domestic dispute, including its nature, resolution, and any related circumstances, to the Queensland Police Service. Explanation. Scenario analysis. This scenario is professionally challenging because it requires the applicant to navigate complex personal circumstances while adhering to strict legal requirements for firearm licensing in Queensland. The applicant's history of domestic disputes, even if resolved, raises significant public safety concerns and necessitates a thorough and transparent disclosure process to the Queensland Police Service, QPS. Failure to disclose relevant information, regardless of perceived relevance or resolution, can lead to license refusal or revocation and potential legal repercussions. The QPS has a duty to assess the applicant's suitability to possess a firearm, balancing individual rights with community safety. Correct approach analysis. The best professional approach involves the applicant proactively and comprehensively disclosing all relevant information to the Queensland Police Service during the application process. This includes detailing the domestic dispute, its nature, the outcome, and any subsequent legal or personal resolutions. This approach aligns with the principles of honesty and transparency mandated by the Weapons Act 1990, QLD, and its associated regulations, which require applicants to provide truthful and complete information. By disclosing everything, the applicant allows the QPS to conduct a full and informed risk assessment, demonstrating their understanding of their responsibilities as a potential firearm licensee and their commitment to public safety. This proactive disclosure is crucial for building trust and facilitating a fair assessment of their application. Incorrect approach is analysis. One incorrect approach is to only disclose the domestic dispute if specifically asked about it by the Queensland Police Service. This is a failure of the applicant's duty to provide complete information as required by the Weapons Act 1990, QLD. Circumstances that could affect an applicant's suitability to hold a license, such as past domestic disputes, are material facts that must be disclosed proactively, not reactively. This approach suggests an attempt to conceal information, which can be interpreted as a lack of honesty and a disregard for the licensing requirements, leading to automatic refusal or revocation. Another incorrect approach is to assume that because the domestic dispute was resolved and no charges were laid, it is not relevant to the firearm license application. The absence of charges is a factor. The QPS is empowered to consider any information that indicates a person may pose a risk to themselves or others. The Weapons Act 1990, QLD, does not limit the QPS's assessment solely to criminal convictions. Domestic disputes, even if not resulting in charges, can reveal patterns of behavior or underlying issues that are relevant to the safe and responsible possession of a firearm. This approach demonstrates a misunderstanding of the broad scope of suitability assessments under Queensland law. A further incorrect approach is to provide a vague or misleading description of the domestic dispute, downplaying its severity or omitting key details. This constitutes a deliberate misrepresentation of facts, which is a serious breach of the Weapons Act 1990, QLD. The Act requires applicants to be truthful and accurate in their statements. Providing incomplete or misleading information is not only a failure to meet the disclosure obligations, but can also be considered an attempt to deceive the licensing authority, leading to severe penalties, including license refusal and potential prosecution. Professional reasoning. Professionals in this situation should adopt a framework of proactive transparency and full disclosure. This involves understanding that any information that could reasonably be considered relevant to public safety or an individual's suitability to possess a firearm must be disclosed. When in doubt, It is always better to disclose more information than less. Professionals should also be aware of the specific legislative requirements in Queensland, particularly the Weapons Act 1990 (QLD), and ensure their actions are compliant. Seeking advice from legal professionals or the Queensland Police Service's Weapons Licensing Branch can provide clarity on disclosure obligations. The ultimate goal is to ensure that the licensing authority has all necessary information to make an informed decision that prioritizes community safety while respecting individual rights. Question 13. The analysis reveals that a licensed firearm dealer in Queensland is approached by a client who presents a valid concealable firearm license and expresses a desire to purchase a handgun for a purpose that seems unusual and potentially concerning to the dealer. What is the most responsible and legally compliant course of action for the dealer to take in Queensland? Option A. Proceed with the sale as the client has presented a valid license, assuming their stated purpose is legitimate and not the dealer's responsibility to scrutinize further. Option B. Dismiss the client's unusual stated purpose as irrelevant as long as they possess a valid concealable firearm license and complete the sale without further inquiry. Option C. Advise the client on how to best articulate their purpose to satisfy any potential regulatory checks, even if the dealer has reservations about the true nature of the intended use. Option D. Politely question the client further about the specific details and practicalities of their stated unusual purpose, and verify any supporting information or references provided, to ensure it aligns with the genuine reasons permitted under the Weapons Act 1990, QLD, and the client's license conditions. The correct answer is D. Politely question the client further about the specific details and practicalities of their stated unusual purpose, and verify any supporting information or references provided, to ensure it aligns with the genuine reasons permitted under the Weapons Act 1990, QLD, and the client's license conditions. Explanation. The analysis reveals a scenario where a licensed firearm dealer in Queensland is approached by a client seeking to purchase a firearm for a purpose that raises immediate red flags regarding public safety and compliance with the Weapons Act 1990, QLD. The professional challenge lies in balancing the dealer's commercial interests with their stringent legal and ethical obligations to prevent firearms from falling into the wrong hands. This requires a proactive and diligent approach, rather than passive acceptance of a sale. The correct approach involves a thorough assessment of the client's stated purpose and a verification of their eligibility and genuine need for the firearm, aligning with the principles of responsible firearm ownership and the intent of the Weapons Act 1990, QLD. Specifically, the dealer must exercise due diligence by questioning the client's stated purpose if it appears unusual or potentially unsafe, and by verifying the legitimacy of any supporting documentation or references. This includes understanding the requirements for different license categories and ensuring the proposed use aligns with the license conditions. The Weapons Act 1990, QLD, places a significant onus on dealers to ensure they are not facilitating the acquisition of firearms by individuals who may pose a risk or who do not have a genuine reason for possessing such a weapon. Ethical considerations also dictate that a dealer should not proceed with a sale if there is any doubt about the client's suitability or the legitimacy of their intentions, as this could have severe consequences for public safety. An incorrect approach would be to proceed with the sale based solely on the client presenting a valid license, without further inquiry into the stated purpose, especially if that purpose seems unusual or potentially problematic. This fails to meet the dealer's obligation to ensure the firearm is being acquired for a legitimate and safe purpose as defined by the Weapons Act 1990, QLD. Another incorrect approach is to dismiss the client's concerns without proper investigation, assuming the license holder is acting in good faith. This demonstrates a lack of professional responsibility and a failure to adhere to the spirit of firearm regulation. Finally, advising the client on how to circumvent potential scrutiny or to present their purpose in a more favorable light, even if technically legal, would be ethically compromised and could be seen as facilitating a potentially unsafe acquisition, undermining the integrity of the licensing system. Professionals in this situation should employ a decision-making framework that prioritizes safety and legal compliance. This involves 1. Active listening and critical assessment of the client's stated purpose. 2. Proactive questioning to clarify any ambiguities or concerns. 3. Verification of supporting information and references. 4. Understanding and applying the specific requirements of the Weapons Act 1990, QLD, and relevant licensing conditions. 5. Consulting with relevant authorities if significant doubts arise. 6. Prioritizing public safety and legal integrity over immediate commercial gain. Question 14. Comparative studies suggest that effective regulation of firearm ownership hinges on robust assessment of proposed storage solutions. In Queensland, an applicant for a concealable firearm license has submitted plans for a firearm safe. What is the most appropriate course of action for the Queensland Police Service, QPS, officer assessing this application? Option A. Accept a standard domestic security safe, provided it is large enough to hold the firearm, as a suitable alternative to a purpose-built firearm safe. Option B. Reject the license application immediately if the proposed safe is not bolted to a solid surface, without further discussion or opportunity for the applicant to comply. Option C. Verify that the proposed firearm safe meets the specific construction, locking, and installation requirements stipulated by the Weapons Act 1990, QLD, and its associated regulations, and confirm its location ensures secure access only to the license holder. Option D. Approve the license application based on the applicant's verbal assurance that the firearm safe is of high quality and will be installed securely. The correct answer is C. Verify that the proposed firearm safe meets the specific construction, locking, and installation requirements stipulated by the Weapons Act 1990, QLD, and its associated regulations, and confirm its location ensures secure access only to the license holder. Explanation. Scenario analysis. This scenario is professionally challenging because it requires the applicant to navigate the specific requirements of the Queensland Police Service, QPS, regarding the safe and secure storage of firearms, balancing the applicant's right to own a firearm with the paramount public safety obligations. The QPS must ensure that the applicant's proposed storage arrangements meet the legislative standards to prevent unauthorized access, theft, or misuse, which could have severe consequences. Careful judgment is required to assess the adequacy of the proposed storage without being overly prescriptive or dismissive of the applicant's efforts. Correct approach analysis. The best professional practice involves a thorough review of the applicant's proposed storage arrangement against the specific requirements outlined in the Weapons Act 1990, QLD, and associated regulations. This includes verifying that the safe meets the prescribed standards for construction, locking mechanisms, and installation, and that the location is secure and accessible only to the license holder. The QPS officer must also consider the applicant's stated reasons for needing the firearm and ensure the storage plan aligns with responsible ownership principles, as mandated by the Act's focus on public safety and the prevention of firearm-related harm. This approach directly addresses the legislative intent to ensure firearms are stored in a manner that minimizes risk. Incorrect approaches analysis. One incorrect approach would be to approve the license based solely on the applicant's assurance that the safe is very strong, without independent verification of its compliance with the Weapons Act 1990, QLD standards. This fails to uphold the QPS's duty to ensure legislative compliance and could lead to the firearm being stored insecurely, posing a significant risk to public safety and violating the Act's explicit storage requirements. Another incorrect approach would be to reject the license application outright due to a minor, easily rectifiable issue with the proposed storage, such as the safe not being bolted down, without offering the applicant an opportunity to rectify the deficiency. This demonstrates a lack of procedural fairness and fails to consider the applicant's right to obtain a license if all legislative requirements can be met. The Act encourages responsible ownership, and a rigid, unyielding stance on minor issues undermines this principle. A further incorrect approach would be to accept a storage solution that is not a purpose-built firearm safe, such as a standard domestic safe, not designed to meet the specific security and locking requirements for firearms under Queensland law. This would directly contravene the Weapons Act 1990, QLD, which specifies the types of safes and their security features required for different classes of firearms, thereby failing to meet the legislative mandate for secure storage. Professional reasoning. Professionals in this role should adopt a systematic approach. First, Understand the applicant's stated purpose for the firearm and the relevant license category. Second, meticulously review the proposed storage plan against the detailed requirements of the Weapons Act 1990, QLD, and its subordinate legislation, paying close attention to safe specifications, locking mechanisms, and installation. Third, engage with the applicant to clarify any ambiguities or address minor deficiencies, providing clear guidance on how to achieve compliance. Fourth, document all assessments and decisions thoroughly, ensuring that the final decision is demonstrably based on adherence to legislative requirements and the promotion of public safety. Question 15. The investigation demonstrates that a firearms safety instructor in Queensland, preparing to conduct a practical demonstration of safe firearm handling for a group of license applicants, has brought several Category A and B firearms to the training venue. The instructor intends to use these firearms for demonstration purposes throughout the day. Considering the requirements of Queensland's firearms legislation, what is the most appropriate method for managing these firearms when they are not actively being demonstrated? Option A. Keep all firearms unloaded and in a locked room at the venue, with ammunition stored in a separate, unlocked container within the same room. Option B. Store all firearms and ammunition together in a single locked safe, but without ensuring the firearms are unloaded prior to storage. Option C. Ensure each firearm is unloaded and stored in a locked gun bag or case, with all ammunition secured separately in a locked container, and both the firearm cases and ammunition containers are kept in a secure location under the instructor's direct supervision. Option D. Allow the unloaded firearms to be placed on a table in the training room for easy access during demonstrations, with ammunition stored in a locked cabinet. The correct answer is C. Ensure each firearm is unloaded and stored in a locked gun bag or case, with all ammunition secured separately in a locked container, and both the firearm cases and ammunition containers are kept in a secure location under the instructor's direct supervision. Explanation. This scenario presents a professional challenge for a firearms safety instructor in Queensland due to the sensitive nature of firearms and the legal obligations surrounding their safe handling and storage. The instructor must balance the need to provide comprehensive training with the paramount importance of adhering to Queensland's firearms legislation, specifically the Weapons Act 1990, QLD, and associated regulations. The core of the challenge lies in ensuring that all training activities, including demonstrations, strictly comply with the legal requirements for the secure handling and storage of firearms, even when the firearms are temporarily out of the owner's direct possession for training purposes. The best professional approach involves meticulously planning the training session to ensure that all firearms used for demonstration are handled and stored in a manner that fully complies with the Weapons Act 1990, QLD. This means that any firearm not actively being demonstrated must be secured in a locked container or safe, and ammunition must be stored separately and also secured. This approach is correct because it directly upholds the legislative framework designed to prevent unauthorized access and misuse of firearms, thereby safeguarding public safety and fulfilling the instructor's legal and ethical responsibilities. It demonstrates a proactive commitment to safety and compliance. An incorrect approach would be to assume that because the firearms are under the supervision of a licensed instructor for a training session, the strict storage requirements of the Weapons Act 1990, QLD, are temporarily relaxed. This is a significant regulatory failure, as the Act's provisions regarding secure storage apply whenever a firearm is not under the immediate control of its licensed owner or a person authorized to possess it. Another incorrect approach would be to only secure the firearms loosely, such as placing them in a locked room but not in individual locked containers or a safe, or to keep ammunition readily accessible. This also constitutes a failure to comply with the specific requirements for secure storage, increasing the risk of unauthorized access or accidental discharge, and thus violating the spirit and letter of the law. Professionals in this field should employ a decision-making framework that prioritizes legal compliance and risk mitigation. This involves thoroughly understanding the relevant legislation, in this case, the Weapons Act 1990, QLD, and its subordinate legislation, conducting a pre-training risk assessment, and developing a training plan that integrates all safety and security protocols. When in doubt about any aspect of compliance, seeking clarification from the Queensland Police Service Weapons Licensing Branch or legal counsel is a crucial step in ensuring responsible and lawful practice. Question 16. A firearms dealer operating in Queensland is approached by a potential buyer who wishes to purchase a semi-automatic pistol. The buyer presents a current Queensland Concealable Firearms license and states they have completed the required application form. What is the most responsible and legally compliant course of action for the dealer to ensure the sale adheres to Queensland's Weapons Act 1990? Option A. Process the sale immediately, assuming any minor errors on the application form can be corrected by the buyer at a later date. Option B. Verify the buyer's Queensland Concealable Firearms license is current. Confirm the license category permits the purchase of a semi-automatic pistol, and meticulously check the completed application form for accuracy and completeness before proceeding with the sale. Option C. Accept a photocopy of the buyer's Queensland Concealable Firearms license as sufficient proof of authority to purchase the pistol. Option D. Accept the buyer's word that their license is valid and the application is correct, and proceed with the sale to facilitate a quick transaction. The correct answer is B. Verify the buyer's Queensland Concealable Firearms license is current. Confirm the license category permits the purchase of a semi-automatic pistol, and meticulously check the completed application form for accuracy and completeness before proceeding with the sale. Explanation. The scenario presents a professional challenge for a firearms dealer in Queensland due to the strict regulatory environment surrounding the licensing and sale of concealable firearms. The dealer must navigate the requirements of the Weapons Act 1990, QLD, and associated regulations, balancing commercial interests with public safety obligations. The core difficulty lies in ensuring that all transactions are compliant, particularly when dealing with individuals who may present varying levels of risk or have incomplete documentation. Careful judgment is required to avoid breaches that could lead to severe penalties, including license suspension or cancellation, and criminal charges. The best professional practice involves a proactive and thorough verification process that prioritizes regulatory compliance and public safety above all else. This approach requires the dealer to meticulously check the validity and completeness of the buyer's Queensland Concealable Firearms license, confirm the license category aligns with the intended firearm purchase, and ensure all required documentation, such as the application form and proof of identity, is correctly completed and submitted. Furthermore, it necessitates adherence to any mandatory waiting periods and the implementation of internal procedures to flag any suspicious circumstances. This is correct because it directly aligns with the Weapons Act 1990, QLD, which mandates strict controls on the sale and transfer of firearms to prevent them from falling into unauthorized hands. Ethical considerations also demand that dealers act responsibly to minimize the risk of firearms misuse. An incorrect approach would be to proceed with the sale based on the buyer's assurance that their license is valid, without independently verifying its current status and suitability for the specific firearm. This fails to meet the dealer's statutory obligation to ensure the buyer is lawfully permitted to possess the firearm. The regulatory failure lies in bypassing due diligence, potentially contravening Section 112 of the Weapons Act 1990, QLD, regarding the sale of firearms to unlicensed persons or persons not authorized to possess that particular category of firearm. Another incorrect approach would be to accept a photocopy of the buyer's license as sufficient proof of authority, especially if the original license is expired or has been suspended. This demonstrates a lack of understanding of the evidentiary requirements for firearm transactions and exposes the dealer to significant legal risk. The ethical failure here is a disregard for the integrity of the licensing system and the potential for facilitating an illegal firearm acquisition. A further incorrect approach would be to expedite the sale by overlooking minor discrepancies in the application form, such as a missing signature or an incomplete address, with the intention of rectifying them later. While seemingly efficient, this practice undermines the integrity of the application process and can lead to administrative errors that have serious legal consequences. The regulatory failure is in not ensuring the application is fully and accurately completed at the point of sale, as required by the Weapons Act 1990, QLD. Professionals should adopt a decision-making framework that prioritizes a thorough understanding of the Weapons Act 1990, QLD, and its associated regulations. This involves establishing robust internal compliance procedures, conducting regular staff training on licensing and sale protocols, and maintaining a cautious approach to all transactions. When in doubt, seeking clarification from the Queensland Police Service Weapons Licensing Branch is a crucial step in ensuring compliance and mitigating risk. The guiding principle should always be to err on the side of caution and uphold the spirit and letter of the law. Question 17. Consider a scenario in Queensland where an applicant for a concealable firearm license has declared a history of domestic disputes with a former partner, although no formal charges were ever laid. The applicant has provided a written statement downplaying the incidents. What is the most appropriate course of action for the Queensland Police Service, as the licensing authority, to take in assessing this application? Option A. Request a character reference from the applicant's current partner to vouch for their good character, and then grant the license. Option B. Dismiss the domestic dispute history as irrelevant to the firearms license application since no charges were laid, and proceed with the assessment based on other criteria. Option C. Grant the license based on the applicant's self-declaration and the absence of formal charges, assuming the applicant is a fit and proper person unless proven otherwise. Option D. Conduct a thorough investigation into the declared domestic disputes, including obtaining a detailed report from the Queensland Police Service regarding the nature and circumstances of these incidents, to assess the applicant's suitability as a fit and proper person. The correct answer is D. Conduct a thorough investigation into the declared domestic disputes, including obtaining a detailed report from the Queensland Police Service regarding the nature and circumstances of these incidents, to assess the applicant's suitability as a fit and proper person. Explanation. This scenario presents a professional challenge due to the inherent responsibility associated with firearms licensing. The applicant's history of domestic disputes, even if not resulting in formal charges, raises significant concerns regarding their suitability to possess a concealable firearm under Queensland law. The Firearms Act 1996, QLD, and associated regulations place a strong emphasis on public safety and the responsible ownership of firearms. A thorough assessment of an applicant's character, history, and any potential risk factors is paramount. The licensing authority must balance the applicant's right to apply for a license with the community's right to be protected from potential harm. Careful judgment is required to ensure that all relevant information is considered and that decisions are made in accordance with the spirit and letter of the law. The best approach involves a comprehensive review of all provided documentation, including the applicant's self-declaration and any supporting evidence. This includes actively seeking further information from relevant authorities, such as the Queensland Police Service, to ascertain the full context and severity of the domestic dispute incidents. The Firearms Act 1996, QLD, mandates that the Commissioner of Police must be satisfied that an applicant is a fit and proper person to hold a license. This requires a proactive investigation into any factors that might indicate a propensity for violence or a disregard for the law. Obtaining a police report detailing the domestic dispute history, even without convictions, is crucial for a complete risk assessment. This aligns with the ethical obligation to prioritize public safety and the legal requirement to thoroughly vet applicants. An approach that relies solely on the applicant's self-declaration without further investigation is professionally unacceptable. This fails to meet the statutory obligation to be satisfied that the applicant is a fit and proper person, as it ignores potential red flags. Similarly, an approach that dismisses the domestic dispute history simply because no charges were laid is also flawed. The absence of charges does not equate to an absence of risk or a lack of concern for public safety. The licensing authority has a duty to investigate the circumstances surrounding such incidents to determine if they indicate a pattern of behavior that would make the applicant unsuitable. Finally, an approach that grants the license based on the assumption that the applicant is innocent until proven guilty without conducting a thorough risk assessment undermines the preventative nature of firearms licensing and prioritizes the applicant's perceived rights over community safety. Professionals in this field should adopt a decision-making framework that prioritizes a thorough, evidence-based risk assessment. This involves 1. Understanding the legislative requirements for licensing, particularly concerning the fit and proper person test. 2. Proactively seeking all relevant information, including police records and any other available intelligence. 3. Critically evaluating the information gathered, considering the potential implications for public safety. And 4. Making a decision that is demonstrably justifiable under the relevant legislation and ethical guidelines. Question 18. During the evaluation of a Queensland concealable firearm license application, an applicant proposes to store their firearm in a locked cabinet within their rented bedroom in a shared house. The applicant states they are a responsible individual and will ensure no unauthorized persons access it. What is the most appropriate course of action for the licensing authority to take, considering the requirements of the Queensland Weapons Act 1990? Option A. Approve the license with a general condition that the firearm must be stored safely, without specifying the exact security requirements for the storage location. Option B. Conduct a detailed assessment of the proposed storage location, verifying compliance with the security specifications for firearm safes as outlined in the Weapons Categories Regulation 1997, and considering the specific security arrangements within the shared accommodation to ensure it is unlikely to be accessed by unauthorized persons. Option C. Deny the license application outright due to the inherent security risks associated with storing firearms in shared accommodation, regardless of proposed security measures. Option D. Approve the license based on the applicant's personal assurance of responsible behavior and their commitment to keeping the firearm secure. The correct answer is B. Conduct a detailed assessment of the proposed storage location, verifying compliance with the security specifications for firearm safes as outlined in the Weapons Categories Regulation 1997, and considering the specific security arrangements within the shared accommodation to ensure it is unlikely to be accessed by unauthorized persons. Explanation. Scenario analysis. This scenario is professionally challenging because it requires the applicant to navigate the complex requirements of the Queensland Weapons Act 1990 and associated regulations concerning the suitability of a storage location for a concealable firearm. The applicant's personal circumstances and the proposed storage arrangement must be assessed against objective safety standards and the potential for unauthorized access, which directly impacts public safety and the integrity of the licensing system. The decision-maker must balance the applicant's right to apply for a license with the paramount responsibility to ensure firearms are stored securely. Correct approach analysis. The best professional practice involves a thorough assessment of the proposed storage location against the specific criteria outlined in the Queensland Weapons Act 1990 and the Weapons Categories Regulation 1997. This includes verifying that the proposed storage meets the minimum security requirements for concealable firearms, such as a compliant safe or strongroom, and that it is located in a place where it is unlikely to be accessed by unauthorized persons. The decision-maker must consider factors like the applicant's living arrangements, the presence of children or individuals with a history of violence, and the overall security of the premises. This approach is correct because it directly adheres to the legislative intent of ensuring firearm safety and preventing misuse, as mandated by the Queensland government. Incorrect approaches analysis. One incorrect approach would be to approve the license based solely on the applicant's assurance that they will be careful with the firearm. This fails to meet the objective safety standards required by the Weapons Act 1990, which mandates specific physical security measures for firearm storage, not just personal promises. It disregards the regulatory framework designed to mitigate risk regardless of the applicant's perceived conscientiousness. Another incorrect approach would be to deny the license without a proper investigation into the proposed storage arrangements, simply because the applicant lives in a shared accommodation. While shared accommodation can present unique challenges, the legislation does not automatically disqualify an applicant. A proper assessment would involve evaluating the specific security measures proposed within that shared environment, rather than applying a blanket assumption. This approach fails to conduct the due diligence required by the Act. A further incorrect approach would be to approve the license with vague conditions, such as store it safely, without specifying the exact requirements for the firearm safe or its placement. This lacks the specificity needed to ensure compliance with the Weapons Categories Regulation 1997, which details the construction and locking mechanisms of approved firearm safes. Such a condition would be unenforceable and would not provide the necessary assurance of security. Professional reasoning. Professionals in this field must adopt a systematic, evidence-based approach. This involves 1. Understanding the specific legislative requirements of the Queensland Weapons Act 1990 and its subordinate regulations. 2. Gathering all relevant information from the applicant, including detailed plans for firearm storage. 3. objectively assessing this information against the legislative criteria, considering all potential risks. 4. Making a decision that is demonstrably aligned with the Act's purpose of public safety and responsible firearm ownership. Any decision must be justifiable by reference to the specific provisions of the law. Question 19. Research into the application process for a concealable firearm license in Queensland reveals a need for thorough vetting. A licensing officer is reviewing an application and must decide on the extent of background checks. What is the most appropriate and legally compliant method for gathering information to assess the applicant's suitability for a concealable firearm license in Queensland? Option A. Accept the applicant's self-declaration at face value for all aspects of their background, including mental health and any past incidents, without seeking independent verification. Option B. Initiate a broad, unfocused background check that includes inquiries into the applicant's employment history over the past decade and their general community involvement, regardless of direct relevance to firearm safety. Option C. Form a comprehensive social media sweep and request access to the applicant's personal financial records to identify any potential lifestyle concerns that might indirectly impact their suitability. Option D. Conduct a targeted investigation by requesting specific information from the Queensland Police Service regarding the applicant's criminal history, mental health history, where legally permissible and relevant to firearm safety, and any documented history of domestic violence or behavior indicating a risk to public safety. The correct answer is D. Conduct a targeted investigation by requesting specific information from the Queensland Police Service regarding the applicant's criminal history, mental health history, where legally permissible and relevant to firearm safety, and any documented history of domestic violence or behavior indicating a risk to public safety. Explanation. This scenario is professionally challenging because it requires balancing the applicant's right to privacy and the need for thorough due diligence by the licensing authority. The core tension lies in obtaining sufficient information to assess the applicant's suitability for a concealable firearm license under Queensland law, without infringing on their personal rights or exceeding the statutory requirements for information gathering. Careful judgment is required to ensure that the investigation remains relevant, proportionate, and compliant with the Queensland Weapons Act 1990 and associated regulations. Best professional approach involves a targeted and legally compliant investigation that focuses on information directly relevant to the applicant's suitability for a concealable firearm license, as mandated by Queensland legislation. This means requesting specific information from relevant authorities, such as the Queensland Police Service, that pertains to the applicant's criminal history, mental health history, where legally permissible and relevant to firearm safety, and any history of domestic violence or behavior that might indicate a risk to public safety. This approach is correct because it adheres strictly to the principles of lawful information gathering, respects the applicant's privacy by limiting the scope of inquiry to what is necessary and relevant, and directly addresses the criteria for license approval or refusal under the Weapons Act 1990. It prioritizes public safety while upholding legal and ethical standards. An incorrect approach would be to conduct a broad, unfocused background check that casts a wide net without specific justification, potentially including personal financial records or unrelated social media activity. This is professionally unacceptable because it exceeds the scope of what is legally permissible for a firearms license application, constitutes an invasion of privacy, and may not yield information directly relevant to the applicant's suitability to possess a concealable firearm under Queensland law. Such an approach risks violating privacy principles and potentially contravening data protection laws. Another incorrect approach would be to rely solely on the applicant's self-declaration without any independent verification, particularly concerning aspects like mental health or past incidents that might be relevant to firearm safety. This is professionally unacceptable as it fails to meet the due diligence obligations of the licensing authority. The Weapons Act 1990 requires the authority to be satisfied of the applicant's suitability, which necessitates a degree of independent verification to ensure public safety and prevent the licensing of individuals who may pose a risk. A third incorrect approach would be to refuse to seek any information beyond the basic application form, citing privacy concerns as an absolute barrier to any further inquiry. This is professionally unacceptable because it abdicates the responsibility to conduct a thorough assessment of suitability as required by the Weapons Act 1990. While privacy is important, it must be balanced against the paramount public interest in ensuring that firearms are not issued to individuals who are not fit and proper persons to possess them. The professional reasoning process for similar situations should involve a clear understanding of the statutory requirements for license eligibility, a commitment to lawful and ethical information gathering, and a balanced consideration of public safety and individual privacy. Professionals should always ask, what specific information is legally required to assess suitability for this license? How can this information be obtained in a manner that is compliant with Queensland law and respects privacy? What are the potential risks to public safety if this information is not obtained or verified? This structured approach ensures that decisions are evidence-based, legally sound, and ethically defensible. Question 20. Governance review demonstrates that an applicant for a Queensland concealable firearms license has proposed to store their firearms in a safe with internal dimensions of 150 cm length, 60 cm width, and 50 cm height. The safe has a wall thickness of 2 cm on all sides. The applicant intends to store 3 concealable firearms, each with an approximate storage footprint of 0.05 cubic meters when stored upright in racks. Assuming the safe's racks do not significantly reduce the usable volume beyond the wall thickness, what is the maximum number of firearms the applicant can legally store in this safe according to Queensland regulations? And what is the remaining usable volume after storing the intended 3 firearms? Option A. The applicant can legally store a maximum of 10 firearms, with a remaining usable volume of 0.172 cubic meters after storing the intended 3 firearms. Option B. The applicant can legally store a maximum of 10 firearms, with a remaining usable volume of 0.372 cubic meters after storing the intended 3 firearms. Option C. The applicant can legally store a maximum of 5 firearms, with a remaining usable volume of 0.272 cubic meters after storing the intended 3 firearms. Option D. The applicant can legally store a maximum of 5 firearms, with a remaining usable volume of 0.372 cubic meters after storing the intended 3 firearms. Correct answer is B. The applicant can legally store a maximum of 10 firearms, with a remaining usable volume of 0.372 cubic meters after storing the intended 3 firearms. Explanation. Scenario analysis. This scenario is professionally challenging because it requires the applicant to accurately calculate their firearm storage capacity based on specific dimensions and volume limitations, while also adhering to the strict safety and legal requirements mandated by Queensland legislation for the storage of concealable firearms. Miscalculation can lead to non-compliance, potentially resulting in license refusal or revocation, and more importantly, compromising firearm safety. The need for precise measurement and calculation underscores the importance of diligence and attention to detail in this licensing process. Correct approach analysis. The best professional practice involves meticulously measuring the internal dimensions of the proposed firearm safe and calculating its usable internal volume. This calculation must then be used to determine the maximum number of firearms that can be stored, ensuring that the total length of the firearms, when stored according to manufacturer recommendations, e.g., upright in racks, does not exceed the safe's capacity, and that the overall storage arrangement complies with the Queensland Weapons Act 1990 and associated regulations regarding safe storage. Specifically, the applicant must ensure the safe's volume is sufficient for the intended firearms, and that the storage method prevents unauthorized access and accidental discharge. The calculation should be usable internal volume equals internal length wall thickness, x internal width wall thickness, x internal height wall thickness. The number of firearms is then determined by ensuring their combined dimensions and storage configuration fit within this calculated volume, respecting any specific limitations on the number of firearms per safe as stipulated by the legislation or the safe's design. Incorrect approaches analysis. One incorrect approach is to estimate the safe's capacity based on a general assumption of how many firearms might fit, without precise measurements or calculations. This fails to meet the regulatory requirement for demonstrable compliance with storage capacity limits and prioritizes convenience over safety and legal adherence. Another incorrect approach is to only consider the external dimensions of the safe, ignoring the internal usable space, which is the critical factor for storage capacity. This directly contravenes the principle of accurately assessing the safe's ability to securely house the firearms as required by law. A third incorrect approach is to assume that if the firearms physically fit inside the safe, the storage is compliant, without considering the specific volume calculations or potential for overcrowding which could compromise safety and security. This overlooks the quantitative aspects of safe storage mandated by legislation. Professional reasoning. Professionals in this field must adopt a systematic and data-driven approach. This involves understanding the specific legislative requirements for firearm storage in Queensland, including any volume or capacity limitations. When presented with a proposed storage solution, the first step is to verify the accuracy of any provided dimensions. If dimensions are not provided, the applicant must be guided to obtain them. Subsequently, a precise calculation of the usable internal volume of the safe must be performed. This calculated volume should then be cross-referenced with the dimensions and number of firearms the applicant intends to store, ensuring that all regulatory requirements are met. This methodical process, grounded in accurate measurement and calculation, is essential for ensuring both legal compliance and the highest standards of firearm safety.